Yes, welcome to this important lecture in our criminal law series, where we are looking at causation and definitional elements, distinguishing result crimes from formally defined crimes in terms of South African criminal law. My name is Dr. Philani and Ndlovu. Thank you very much for being part of this discussion. Without wasting time, let's go on to the main body of today's work. Yes, we have four elements of criminal liability, which we have already been speaking about in some of our lectures. We have a voluntary human act or omission as an important element. Then we have definitional elements such as causation, we have unlawfulness, and we have culpability. Each one of those is dwelt within a separate video. So make sure to follow up those videos. First and foremost, let's understand what a crime is. According to maybe the definitions that are often given, each crime is defined differently. So you find that when you talk about murder, or you talk about rape, or you talk about theft, each one of those crimes has got its own elements or requirements. Those are what are called definitional elements. So remember that the law does not just prohibit acts in a vacuum, but only in respect of specific circumstances. For instance, sexual intercourse is legally permissible, but non-consensual sexual intercourse is a crime. It is called rape. Driving a motor vehicle is not an offense, but driving without a valid driver's license is an offense. So a definition of a crime gives a full description of the crime in terms of what act or omission is prohibited in terms of the specific requirements related to that crime, and it provides a formula to determine when a crime has been committed. Elements specific to a specific crime are called its definitional elements, what Professor Snyman calls the definition of proscription. And each crime has its own unique definitional elements. So in other words, whenever we are thinking about a crime, you find that the reading, whether the statute or looking at the common law, it provides a formula to determine when a crime has been committed. General requirements such as voluntary human act, unlawfulness, criminal capacity, and culpability apply to all crimes. Yet each crime has got its own specific requirements or its own specific, defining elements. Those are what are called the definitional elements. It is very critical then, as a point of departure, to distinguish between what are called formally defined crimes from what are called materially defined crimes. Now, materially defined crimes are also known as result crimes. There is a distinction between these two because formally defined crimes are not result oriented, whilst materially defined crimes are result oriented. That's based on their definitional elements. So a formally defined crime could read as follows. It could say murder, or rather rape, is the unlawful and intentional carnal intercourse with a person without their consent. So it does not prescribe a particular result, but it prohibits a particular action. So whether the woman raped eventually falls pregnant or not, that's not the point. So you see, these formally defined crimes therefore are not looking at the result. Theft is the unlawful and intentional appropriation of property belonging to another person. And then the issue here is appropriating or taking over what's not yours. And then materially defined crimes or result crimes, on the other hand, prohibit all action which causes a certain result. Hence, they are called result crimes. For example, you have a person's death, notwithstanding the method used to kill them. It could be shooting at them, or administering a poison, throwing them from the 25th floor of the building, or driving a vehicle over them, whatever it might be. What we are concerned about, what the definitional elements of the crime are concerned about, is the result rather than the method. So it's very important to remember how murder can be committed differently from, of course, culpable homicide, whereby murder is the unlawful and intentional cause of the death of a person, while culpable homicide is the unlawful and negligent cause of the death of a person. So the question of causation relates only to result crimes and not to materially in fact, yes, it relates to result crimes which also happen to be materially defined crimes. Causation does not apply to formally defined crimes. That's very important to take note of. So what then do we mean by causation? It is it is that link between an act and the result. Materially defined crimes always seek to establish that causal nexus, to say the presence of A causes or results in the presence of B. That's the causal nexus. So in materially defined crimes, there should be that causal nexus between the conduct of the accused and the prohibited outcome or the prohibited result. Determining a cause is not always a straightforward matter. It's easy to determine a causal relationship in cases in which an act immediately results in the prohibited act. But what happens in cases where there are supervening incidents between the prohibited act and the final act? Take an example where X, with the intention to kill Y, shoots at Y, who immediately flees into a building, which soon collapses due to an earthquake, killing Y in the process. Or take another incident where X shoots at Y and the friend of Y driving Y to hospital gets involved in a fatal road accident in which Y dies. So did X cause the death of Y in these circumstances? Very tricky questions. Maybe you have better answers for me. Let's proceed and see what the next part of the discussion says. I hope we'll be able to unravel some of these matters as we proceed. So, determining causation at law can be very, very problematic, because sometimes you find the conduct of the accused does not lend itself to an easy and determinate conclusion whether indeed it caused the result. So the conduct of the accused must be both a factual cause and a legal cause. And the accused's act is a factual cause if it is a conditio sine qua non for the result. And the accused's act is a legal cause if there are policy considerations in terms of which the accused must be held accountable. That's very important to take note of that. Now let's explain what we mean by factual causation. It is a conditio sine qua non. It is a condition antecedent without which a result would not have occurred. So if we say X, or rather the presence of a point of fact A leads to fact B, we are saying that A is a condition sine qua non for B. It is also called a but for or a without which condition. The question is, would Y have resulted if X had not occurred? Would Y have died if X had not shot at him? If we cannot think away the result without the act itself or the result disappearing, then it is the factual cause. Case law, we have the Macaulay case of 1950, the Daniels case of 1983. These are very significant cases to look at. They elaborate on some of these issues raised here. Now, talking about legal causation, we have what we call the conditio sine qua non principle, whereby we say that it is a but for or a without which. We are saying that if A had not occurred, B would also not occur. And we are saying that this principle is too broad and it is far-reaching. Some people call it the Adam and Eve causality, whereby we might end up saying if X had not been born, Y would not have been killed. So we can stretch it further and say if the parents of X had not given birth to X, then X would not have been there to kill Y. Maybe take it backwards and say if the grandparents of X had not been there in the first place, so they would not have given birth to X, and X would not have killed Y. So hence we call it the Adam and Eve causality. It is insufficient in explaining some of these daily issues that we encounter that the courts have to deal with. So it has to be augmented with legal causation theories, where courts apply some of the following theories, such as individualization theories, the theory of adequate causation, as well as looking into whether there's been an absence of the novus actus interveniens. And what we mean by individualization theories, we are looking at the most operative condition among all factors, the most operative, one closest to the incident, which qualify as factual causes, what some people call the proximate cause. Now, the theory of adequate causation is a generalization theory which says if, according to human experience, an act has a tendency to bring about a certain outcome, it is the cause for the prohibited result. Now, the absence of a supervening or intervening event, which is called a novus actus interveniens, it means that the act or conduct of X is responsible for the result Y. But if there is a novus actus interveniens, then the conduct of X is not the direct cause of Y. That's very important to take note of. And then, what do we mean by that supervening event, which is called a novus actus interveniens? If a new and an unexpected or an unusual event which deviates from what is expected in normal human experience occurs and interrupts the chain of events, then X's act is not the cause of the result. So in other words, the absence of a novus actus interveniens establishes the connection. So the question will always be, do the events serve as do the supervening events serve as an intervenience of some kind? Look at the scenarios below. We dealt with this earlier on. Let's look at them again. X, with the intention of killing Y, shoots at Y, who immediately flees into a building. Then the building collapses due to an earthquake and kills Y in the process. So we are saying here that some people might argue that it is not the shooting of Y by X, which caused Y's death, but it is the earthquake. So the proximate cause would say, yeah, it's the earthquake that killed Y. But another person might argue that if X had not shot at Y would not have run into that building. So even if an earthquake occurred, Y would not have been inside the building in the first place. So Y only ran into the building to escape the harm that X had actually was inflicting on her. Or X shoots at Y, and then a friend driving Y to hospital gets involved in a fatal accident in which Y dies. Again, so we've got an intervening event there. And the question is, how far does this event account for, you know, the death of Y? So that's what happens when we're trying to apply some of these theories that are based on what they call the legal causation. So, because the issue of establishing causation is not straightforward, we find that courts defer to a combination of these theories instead of exclusively applying one. So, in order to establish a causal link, both factual and legal causation must be present. So the conditio sine qua non test must be applied together with what we called the legal causation theories of the generalization theories, looking for the proximate, the most operative cause. So, or besides the generalization theories, you may look at the adequate what you call the adequate cause theory, whereby we are saying if a certain event is likely to, in ordinary human experience, an event is likely to cause a certain outcome, then when such an outcome has been caused and that act was present, then it did in the current scenario cause the outcome. So that's what adequate causation says. And then, of course, looking at the absence of the novus actus interveniens, we then come to conclude that if there is no intervening event, then the conduct of X was responsible for the prohibited result in the scenario. So in order to establish a legal, what cause the causation, the courts apply both the conditio sine qua non, which is a factual inquiry. It's combined with a legal causation, where policy considerations require an application of legal causation, which is established through the the combination of the individualization theories, adequate causation theory, as well as the absence of a novus actus intervenens, which is a very unexpected and different and anticipated intervening event. Yes, we are coming to the end of our discussion, and we are saying this lecture began by outlining the meaning of the term definitional elements. It then distinguished between formally defined crimes from materially defined crimes. And then it disclosed that causation is a key element of materially defined crimes, also known as result crimes, and it explored the different theories of causation. And then it highlighted that the fact that establishing causality is one of the most problematic issues in establishing criminal liability. And then it established the fact that courts apply a combination of theories to resolve these issues. And Certainly, this was this is a video that has dedicated itself to definitional elements and causality. I've, I've got others on unlawfulness, culpability, and all involuntary human act, and so on. So please ensure that you follow those up in order to broaden your understanding on these areas. Thank you very much.